All right, people, I think we're live. Let me see what I look like here. Oh, no. I'm sweating. I just got off the treadmill maybe a half an hour ago, and I have not yet cooled down, so I'm going to be glistening. No air conditioning yet. Someone had asked me either by email or message, no air conditioning yet. That has been fixed because the wait was 6 weeks to get somebody who can fix those wall mount units. And no merch today. Oh, this is terrible because I'm wearing my alma mater shirt, Université Laval. I really am sweating quite a bit. So that's it. That is the intro stuff. I sent Robert the link this time, so he's going to come. He's ready. We're going to go as soon as he's in. And this is going to be a phenomenal, I mean, they're all phenomenal, but this is going to be jam-packed because in the week that I took off from the live streams to go on a road trip, what happened? Things go crazy. Things went crazy. Why are you always so sweaty? Jeez. Yeah, this is the problem of exercising too soon before a stream. Should learn my lesson. I should learn my lesson. I will. Okay, so it's good to see everybody again. What developments happened in the last 2 weeks? Akilah obviously was ordered to pay Sargon of Akkad's legal fees. Phenomenal judgment in the legal sense. If someone says they can't tell that I'm sweating, all the better. We had the Sullivan update, and then we had an update in the Sullivan update since the last update. Airlines lawsuits. We're going to talk about the NRA lawsuit. We probably will get to, but I don't know anything about it, so I'm going to need, Robert's going to have to carry the discussion on that one. Crazy. This is the new normal. I was having a couple of ongoing discussions with friends that if we're talking about the same crazy being the new normal, then yeah, it's madness. Incidentally, by the way, everyone, send out the link, tweet it out, because sometimes YouTube is a little slow for the notification. Oh, Akilah is still running her mouth. Oh man. I mean, we're going to talk about it with Robert because someone had actually asked me, it was either Twitter or email, I forget which. I always say don't take your battles to social media, especially your ongoing legal battles. And Robert does it in a way that I think doesn't ultimately compromise his positions. And I think he does it strategically. And my gosh, okay, if you guys, this might be embarrassing. Oh. Okay, so what was I saying? Robert, we're going to ask Robert what he thinks about how to do it in a manner that is strategic and doesn't compromise your case, your position, when it's good to do it and when it's not good to do it. And then what else? The Akilah, obviously, case is going to be very interesting for the Keemstar case, because I didn't do a follow-up on Keemstar or Romeo Lacoste versus Keemstar, but Romeo Lacoste sued Keemstar, had his lawsuit dismissed on an anti-slap legislation, and Keemstar was going after him for the legal fees. It wasn't copyright infringement, so it might be totally different. But that's it. What else happened? Too many things. I see Robert's in the house, and you guys are going to flip out when you see what Robert is wearing compared to what I look like now. Incidentally, I'm never doing the suit again unless there's a darn good reason. And I had a joke the last time. The last time I was wearing a suit on the upper half, and I actually had flamingo shorts on the bottom half, but I didn't think it would have been a polite joke to make, but it would have been hilarious. I'm never doing the suit again. It's even with the shaved face. Viva, go change your shirt. It's already soaked. When I bring Robert in, the wetness of this shirt will be minimized, pun intended. Let's bring Robert in. Oh, sorry, hold on. Before I get there, super chats. I'm going to thank you all in advance for the super chats. Robert and I have been splitting them, and I send them to Robert afterwards. I cannot promise to get to all the super chats. I apologize in advance for not getting to some of the super chats. It's going to happen. I try to bring up non-super chat questions as well. Thank you for the support. We genuinely appreciate it. Super chats that are really off topic are harder to get to and harder to work in because it interrupts the discussion. Super chats that are on topic are definitely easier to get to. One way or the other, if I don't get to them, I apologize in advance, but that is the nature of the beast. It is to show support and not a right of entry into the conversation, because oftentimes I don't want to interrupt Robert and then I can't go back and see all the super chats and, mea culpa, but in advance. let's just say so the first one that I saw. Can you guys talk about executive orders? Is Trump a genius for getting Dems to argue against his efforts at COVID relief? You know what? Let's bring Robert in, and we're going to talk. And wait until you see style versus the alternative. Robert, how you doing?
Good. I got my. I'm hoping college football does take place, and in that capacity, I have my orange and white Tennessee outfit ready to go.
It is beautiful. I guess I can't even think about wearing white like that because it would last. It would stay clean all of 30 minutes in the morning until a dog pees on me or a kid, does something. You look good. How you doing? It's been 2 weeks. It felt like a long 2 weeks.
Yeah. I mean, it's amazing that the legal news does not dissipate at all. I mean, even in the like normally the courts take this time of year off. Not so much this year. August is usually court vacation time, lawyer vacation time, but there's been no vacation time in the Trump era, so it's been fascinating.
It's amazing. It's amazing. So let's start with the first super chat, and then we can get to another super chat that's on topic. Can you guys talk about the executive orders? Is Trump a genius for getting Dems to argue his efforts at COVID relief? So he signed an executive order. What did the executive order provide for? Because I don't know the exact details. I just know that Nancy Pelosi called it unconstitutional slop.
Well, the only thing that they really can argue about is the actual spending parts of it, because the other parts they don't really have an objection to meaningfully, legally at least, and that's suspension of evictions for certain loans that are federally guaranteed, preventing evictions and things of that nature. Also, for federal student guaranteed loans, not collecting on interest or those loan payments for a period of time. Things like that were included in there, they really don't have much legal argument with. That's clearly within his executive discretion. Their main argument is that they thought they had a sort of had him over the barrel in demanding that all of their packages get included or unemployment would run out. And that was the goal. And so what Trump did is he said, well, I have emergency authority under the COVID Emergency Act. There's been a whole bunch of funds, and people have not been paying close attention outside of the, your George Gammon types. Outside of that, they haven't been paying attention to how much money is actually in those accounts potentially for emergency spending. The Treasury General Service account is sitting at $1.7 trillion. That's how much is available to spend related to emergency spending. So they would have to claim that there's no causal connection or correlation between the pandemic and Trump's saying, I'm going to give certain amounts for unemployment compensation, and it'll go up more if the state matches it. And so I don't think their legal argument is quite as strong as they think it is. And I do agree with people who say politically there's no winning that with the Democrats suing to stop Trump from giving unemployed people money related to a pandemic. I get they wanted it as leverage to demand that he include, a bunch of money for mail-in ballots, a bunch of money for to bail out state governments who've ordered these extreme lockdowns, things of that nature that he has no interest in. They wanted to spend, I think, close to $3 to $4 trillion, which is kind of insane when you look. I mean, the entire U.S. economy is about $23 trillion. We've already spent $3 to $4 trillion, depending on how you evaluate it. The Fed has added another $3 trillion to its balance sheet. We're supposed to spend up to 50% of the GDP within a 6-month time period, just the government, when there's diminished tax revenues. Where they think this is going to come from is interesting. But so I think politically, it was a no-lose bargain for Trump. Even if he doesn't win legally, the Democrats sued him to stop unemployed people from getting money. He reversed the script. They wanted to say Trump is denying unemployed people money because he won't go along with their package. Now he put them in a position where they either have to accept it or they have to sue to stop unemployed people from getting money. I'm not sure they're actually going to go through with the full scale of the suit. My guess is they might sue but not seek injunctive relief, that kind of thing, because it was a win-win for Trump, and it was smart of Trump to be politically aggressive. In terms of his legal authority, the Emergency Spending Act, the provisions that are available, both the funds actually being available in the Treasury's General Service account and the breadth of the emergency spending laws do appear to me to give him that authority. Where people are right that are criticizing him is that this is an unusual use of emergency spending. But this is an unprecedented emergency. We've never shut down part of the economy for a pandemic. Never happened before. So to me, I think he's in pretty good stead, both legally and politically.
Okay, interesting. Without more on that, let's start with Akilah versus Benjamin Hughes because it's the easiest one to deal with. the update in that is that Akilah Hughes, after having had her copyright claim against Sargon of Akkad thrown out, was recently ordered to pay the legal fees, Sargon's legal fees, which in the order of $38,000. As far as I'm concerned, and in my limited knowledge of American copyright law, it seemed to be a very well-justified, well-reasoned decision that addressed all of her arguments and sort of systematically rebutted them one by one. She had said that, he raised money on GoFundMe, so he's not out of pocket. They said that that's irrelevant. Ordering her to pay the legal fees would further the intent of the Copyright Act, et cetera, et cetera. I mean, on the judgment itself, do you have any major disagreement, or is it a no-brainer?
It was a complete no-brainer, and she got very lucky that the fees were as low as they were. So normally someone would have, for litigating that, would have been a $75,000 to $100,000 kind of fee award they would have requested in New York. And she was given multiple opportunities to withdraw the complaint without having to pay fees, refused to. It was a patently frivolous lawsuit. Frivolous both under the copyright laws, in my view, frivolous, period. That's why her first lawyer jumped ship, who, by the way, she then attacked on Twitter.
Yeah, we're going to get to that.
It was for folks out there that I'm looking at trying to bring ways to stop this copyright abuse, which is taking place. There's two forms of it. One form is legal, one form is not legal. The legal form that's taking place is people are being targeted for political purposes, in my view, misappropriating the copyright laws to target the Alex Joneses of the world for suit. For every single Breitbart's been targeted in the same way. They're facing disproportionate number of suits from what they call copyright trolls in the business. Now, those suits are legitimate suits, but what they're doing is they're seeking 10 to 100 times the value that they would normally get for whatever the copyright infringement was. And so I did a bunch of these cases for Jones. We ended up getting good settlements in all of them. Pepe dismissals and some others. In the Pepe case, they ended up getting $13,000, for which they estimate they spent about $1 million worth of legal fees. They volunteered the legal services, but still doesn't change the fact that they wasted $1 million trying to collect 13 grand. But there's a lot of these cases where the copyright laws have been abused. And her case was classic because her complaint alleged something that by its own statement, and this was the judge pointed this out right away, did not constitute a violation of copyright law. For folks out there, the point of copyright law is to protect the inventiveness of ideas and creativity of ideas. And in that context, it also wants to protect people who want to criticize something, being creative in that process, being informed in that process, being inventive in that process. So it's called fair use doctrine, which means, so if someone's stealing your copyright to profit off of it, that's problematic. When, by contrast, when somebody's using your copyright to comment on it, they are creating, in my view, their own form of a copyright. And in some contexts, actually, it's recognized as such. And so what's been happening is people have been filing suits. So a lot of people get YouTube strikes for completely bogus grounds because the big tech is conspiring with big media to use algorithms to target any. I used it as an experiment on I have a small web page, YouTube page. And I do it often just to see how YouTube is handling different things. And YouTube actually issued me it wasn't up to a copyright strike. It was a copyright notice. And it was a copyright notice for using Vice footage that I didn't use. I just verbally referenced it. But that told me, okay, their algorithms are verbal, not visual. So so I was like, okay, from now on, I'll just say, look at this interesting something from somewhere, But that's all protected under fair use. So they're completely, and in fact, there's a legal provision that allows you to sue when someone's abusing copyright laws. It just hasn't been enforced a lot. And I'm looking into that because I think there's been a lot of abuse by copyright holders against people that are actually not violating the copyright laws. Hers was just a more egregious case. She knew this from day one. She was told this by Carl Benjamin, popularly known as Sargon of Akkad. And she still filed suit. The lawyer told her this was going to happen. She still went forward with the suit. Then the judge told her this was going to happen. She still went forward with the suit. And then the fee request was made. And instead of settling the fees, she probably could have settled 30 grand, gone home. She contested the fees, which, by the way, will entitle them to more fees. For having to fight over fees. And if she appeals even more, the judge who was presiding over the case is a circuit judge sitting by designation. So some people might have been confused by seeing a district court issue a decision by a circuit judge. It's because sometimes our district court judges will sometimes sit on the circuit, by designation, and sometimes circuit court judges will sit on the district by designation. One of the only places they cannot do that is en banc decisions, which we'll get to later, involving another case. So so it was an easy win. No chance of her getting reversed on appeal. High chance of her getting more fees assessed against her. Her argument that he got money elsewhere doesn't matter. This is like insurance cases. So like when you're in a personal injury accident and your insurance pays your medical bills, the defendant doesn't get the benefit of that. You get the benefit of that. So often, like in a personal injury case, there's a typical ratio for people out there wondering. It's usually 2 times your medical bills in the United States. So if you have an accident, the other side is responsible. Let's say you have $12,000 in medical bills, but let's say you only really paid like $500 co-deductible or whatever out of it. You get the whole $12,000. And then usually you get $24,000 for pain and suffering. Ends up being $36,000. A third of that typically goes back to the lawyer, $24,000, some legal fees. But basically, you get back the benefit of the medical bills even when you didn't pay those medical bills. It's the same principle. The fact there's a third party beneficiary has nothing to do with whether or not she's responsible for legal fees for filing what was frankly one of the most frivolous copyright suits I've seen.
Well, so now here I disagreed with this at the very beginning. In principle, is that I didn't think it was so frivolous on its face in terms of a copyright claim, because for anybody who hadn't seen the video, her original video was called "We Thought You Would Win." It was, I don't know, say a 12 or 15-minute video. Sargon's video didn't modify in the technical sense. It didn't caption. It didn't like meme. It was just sort of certain cuts conveniently placed, conveniently made that restructured the original video into a shorter video, 7 minutes. So. Or not, maybe 9 minutes. But it was a long video that did not transform in any physical sense. It didn't transform in the cartoonish sense. He didn't audio over. He didn't make any verbal commentary. It just re-edited the video and called it SJW levels of awareness, where it was the original video, original bits, and it was just clear what the commentary was.
Right.
So I think
that's the key part.
Yeah, well, that's it. So what ended up happening is she
the
filed
second key part is she was dumb enough to say that in her lawsuit.
Okay, that's where it's different. Now, if that had been the only issue, I could say
if she would have said, "Hey, Sargon's trying to take credit for my genius," and is crediting it, then it would have been different. But instead, the whole lawsuit was, "Oh my God, he's making fun of me," and that's why the judge was like, "That's exactly what fair use is about."
The judge said 2 things in the original decision was, you admitted that he was mocking and demeaning you. That is commentary. And besides, you're not, one of the criteria, you're not targeting the same audience. It's not like he's stealing any money.
He's not trying to pretend he's you for purposes of stealing something unique you created. If she had alleged that, it would have been very different. She would have survived the motion to dismiss. She wouldn't have survived summary judgment because of what happened, but she would have survived the motion to dismiss. The problem was, as soon as she put in there that the reason why she was suing was because she said, "This is mocking me."
Yeah.
Well, that's commentary, fair use, classic version.
So she literally said mocked and demeaning. Then the judge says, "Look, that's quintessential fair use in some pre-trial hearing." She pursues, makes a settlement offer after the judge says you've got no case. Her settlement offer was for $48,000, which was like, how you even think you're entitled to that, even if it were bona fide copyright infringement.
Correct.
And so that's it. So the judge came down hard. Now, the judgment was very well drafted. A lot of people were asking, if she appeals and fails in her appeal, those legal fees get added on, so she has some sort of incentive not to pursue an appeal.
Yeah, no doubt about it. Plus, when you have a circuit judge sitting by designation, I mean, every circuit judge knows this other circuit judge. It's just not, your chances are nil. I mean, so apparently she's looking for lawyer number 3, because apparently she can lawyer number 2. Now she's interested in lawyer number 3, decided to libel Sargon of Akkad in the same tweet thread, while she, of course, attacked the judge. Now, I personally, I have a different take on that. I'm for more criticism of judges. I got family that sit on the bench. I got close friends that sit on the bench, and I've told them the same. And they don't mind. They actually share my sentiments for the most part. But that we have too little criticism of judges. So I'm not as critical of parties who are critical of judges, because I think judges need to be subject to more criticism. Now, it is often not the best legal strategy to pursue. But she hasn't shown any signs that she has any interest in that anyway.
As a circuit judge, is Sullivan, and Sullivan is the judge, not, wait a minute, is this Judge Sullivan?
I think it's Anderson or something like that.
Okay, well, whatever his judge's name is. As a circuit judge, is he elected or is he appointed?
Everybody's appointed because they're all federal. So
Okay.
this is the federal Second Circuit judge sitting by designation in the Southern District of New York.
So when she takes to Twitter afterwards, says, know your judge, posts, I don't think it was confidential or personal information, but, know your judge, and says something like, and get out there and vote so that more judges like this don't get elected to the bench. This judge was not even elected in the first place. It's not like he's subject to a vote for re-election.
Yeah, it's only appointment. So now you can't influence, obviously, judicial appointments through elections since the Senate has to consent to their appointment and the president nominates them in the first instance. And this was a George W. Bush appointee, I believe. And so but yeah, it's the problem was she clearly doesn't even understand the law still. I mean, she was trying to say, oh, they got confused. I was really trying to bring a copyright claim, not a harassment claim. I was like, yes, they understood that. That's what you didn't get. That's why you lost. So the incapacity to understand basic logic is really rather sad.
It the irony, and a lot of people were commenting on this, is that the reaction illustrates the exact intent and purpose of Sargon's video in the first place, which was there's no level of awareness, there's no level of reflection, stepping back and just trying to understand. She loses at every stage, which in justified in law, justified in fact, and after getting smashed for what she did on Twitter in the interim, after she loses, goes right to Twitter. I agree. She, I don't know if you call someone, the WS word or the white supremacist. I don't know if that's slander.
What it is she makes very specific statements about what happened to him vis-a-vis his election campaign. So the white supremacist, she might be able to get away with, that's still right now, that's hard to sue on in the United States. That might start to change. We'll see. But it's specific statements she makes about what happened to him in the election campaign that when I looked at it and saw Count Akilah and other people's interpretations, and from my recollection, it's not true what she's saying about him. And that was more factual statements. So I mean, I don't think I responded to her. I think he's put out a general tweet just saying, by the way, if you lose a lawsuit for filing one frivolous suit, you probably shouldn't libel the person who just won against you. But, take and not only that, for all of this hassle, she's out 50, 60 grand at least in her own fees, plus these fees. And she made Sargon, Carl Benjamin, $100,000 plus richer. So, congratulations.
And not just that, but now she's seemingly trying to crowdfund for her fees. And part of me questions whether or not she knows that it's all, a correct decision, but trick enough people to flip, to donate money to you and you can sort of fund your bill. I want to bring up one comment because, first of all, I love the comment. Paul Greenleaf says, you are both patriots for your work, even the Canadian. First of all, thank you.
That's funny.
But what I love about this color matches what you are wearing, Robert, in a way that is almost planned.
That's true. Yeah, exactly.
And if anybody's listening on the podcast, it's beautiful white, orange, and beige, or whatever the color that is. So now, this brings us back to the original question. The original question was, well, someone asked me, what's your advice on taking your legal battles to social media in terms of public statements? Like I say, never do it. I know that's sort of the extremist because there are exceptions and there are times where it will help. What's your position? What's your advice on that?
I generally, it depends on whether the case is one where the court of public opinion is important. So if the court of public opinion is important, then you need to defend yourself in the court of public opinion, though you're better off generally if it's not you yourself having to do so. So if it's somebody else doing it on your behalf, it should be your lawyer, a good skilled lawyer defending you in the court of public opinion. Then you can retweet it and so on and so forth. But sometimes you have to fight your battle in the court of public opinion. The Roger Stone case being a paramount example of that. General Flynn, which we'll talk about, being another example of that. Alex Jones has to defend himself. He at least has to have someone do it on his behalf in the court of public opinion. I was recently on a PBS Frontline piece, which 98% of it was a hit piece. They did allow me to say two nice things. That was about it. In that kind of context, you need some sort of counterpoint. You need some sort of counterpunch. You need somebody to know that there's another side of the story out there. So I think, and this was all about a PR case on both sides. So I think in this context, defending yourself, arguing in the court of public opinion is just fine. You're better off, though, if it's someone other than you personally, ideally doing so. That a good lawyer will be a very effective advocate for you in the court of public opinion, because what they say in the court of public opinion cannot hurt you in a court of law for the most part. In other words, it can't be used against you as factual testimonial evidence, for example. And in the way this was used against her. But in the same context, They often are just better at it, particularly if they're skilled at it. They're more familiar with the media than most people are. Roger Stone probably being an exception, but other people being better at interacting with the media, and in particular knowing how the media and the law interface. So knowing what to say, how to say it, where to say it, when to say it. Like there isn't a time to bring questions about judges, but there's a way to do so. After you lose at the very end and whine, that doesn't sound persuasive at all. On the other hand, like in Roger Stone's case, my advice to him and others had been to point out, I would have moved to disqualify right away on grounds that they had manipulated the judge's selection and that the judge had shown overt bias in ways that suggest an impossibility to be impartial. Because that's what's going to happen, so you just get ahead of the curve. Here, this judge would have been happy to rule in her favor if she had any quality copyright claim. This judge wasn't biased against her politically or personally. It was because the judge he kept warning over and over. There are a lot of other judges who would have been much harsher with her, who would have issued sanctions for frivolousness and other things. He didn't do any of that. So he could have given signals that he would go higher in the fees. There's grounds to do a lodestar amount where you multiply the effect. He did none of that. He kept telling her, by what you're describing is not a copyright violation under United States copyright law. And she just ignored it. And the way we can fairly infer that she ignored it is she had to keep flipping lawyers. So that meant lawyers were saying, no. Now, anybody can make this kind of legal mistake. James O'Keefe, won't get into the details of the NRA, that part of the gun rights suit. But his lawyer filed a suit in federal court against the FBI in the United States of America, in which he alleged a 1983 violation. Well, I understand people occasionally get confused on this, but not usually a lawyer who files suit in the Southern District of New York, or in this case, the Northern. Well, no, yeah, that one's the Southern. The NRA is the Northern. But the 42 USC 1983, while it's a federal law, it only applies to state, local, city, county governments. It does not apply to the federal government, and almost anyone would know this. And so I felt that was kind of bad because usually O'Keefe has really good lawyers. James O'Keefe, Project Veritas, for people wondering who that is. He appears to have been wrongfully denied access to purchase a weapon because he's been wrongfully placed on the do not sell list by someone who lied and said that he had a felony conviction when he never has. He had a minor misdemeanor conviction for ambushing a senator inside a federal building and he was undercover, so he didn't tell people while he was there. Only such prosecution I've ever heard of, purely politically motivated prosecution. A lot of misconduct in that case. But either way, for everybody out there, civil rights laws only apply to the states. The way you sue the federal government is by a specific federal statute that waives sovereign immunity, or you allege a constitutional claim, which is called a Bivens claim, after the case of the same name, Bivens versus 6 unnamed agents, that was decided by the U.S. Supreme Court, that said you had a right to bring that claim. But notably in the Bivens case, you do not get your legal fees back. So the main incentive for lawyers to bring federal civil rights claims is that the legal fees can be recovered, so they can do it pro bono up front and just and if they win, recover. And I'm currently in a fee battle in Virginia over a case that I won. But in the Bivens context, there is no such award. But it was unfortunate to see that kind of mistake. So people make those mistakes on both sides. But here, she was warned repeatedly. She was warned by Sargon. She was warned by the opposing lawyer. She was warned by the judge. She was likely warned by her own lawyer. And she just marched right on.
Well, the thing is, it was the judicial admission that it was mocking and demeaning, which I presume even if she tried to redact that or amend it out of the proceedings, no one would ever let that come out of the proceedings. If the argument had been he used 7 minutes of a 15-minute video, he didn't need to use that much to make his point. He could have made it, he is profiting off my work not by passing it off as his own, but rather by using more than he has to of the original, so nobody has to go watch the original now. Those are the arguments I would have made. But that would have been a stretch.
I mean, really what copyright's about is when somebody steals the credit for my invention rather than uses my invention to create one of their own. And even though he was using solely her words to create it, that's often done in the video context. Is using somebody else's words to indict them. When it's like that any good copyright lawyer would have told her, you don't have a claim here. I didn't recognize the name of any of the lawyers who worked on her case. And I know a fair number of the people in New York on the copyright context. So that told me that she probably went shopping. And my guess is a bunch of lawyers told her she had no claim until she found a lawyer who could take the bait, who thought, oh, it'll be a big political case, and didn't know what copyright law worked, and thought copyright is just, hey, whatever I create, no one else can. It's like those people that are suing Carpe Diem for making a meme of that image of those two kids. And like their Twitter and a false copyright claim, in my view, had led to him being off of Twitter. So I think there's got to be some way to combine those into a legal claim somewhere, but I got to figure that out. But but in that context, it's just sort of that's exactly what fair use is for. Copyright law was never meant to be like people sometimes confuse copyrights with patents. Because like a patent, you can't use at all, any part of, without certain kinds of permission. That's not the way copyright law is. Copyright is to protect creativity and inventiveness. And if that creativity and inventiveness is applied to use your original idea to create a new idea, that's totally protected, because we want to protect creativity. What we're protecting is not your invention. We're protecting the actions of creativity and independence of thought in the first place, and of inventiveness of ideas in the first place. That's why anything that can be called commentary will almost always be exempt from copyright law, with the exception sometimes of a photo. So if you use a photo and it's not really part of the commentary, it's part of something else, then it's harder. That's where they're most protected. That's why photographers have become the biggest copyright trolls in the country now, because they used to get like, say, $100 for a licensing. And now they realize, hey, I can get a lawyer to sue and get 10 grand. And the lawyer claims statutory violations for which they can get $150,000 per time the photo was used. Now, I think that part of the law is going to change in its interpretation over time, but that's the full context of copyright law. But this is in my view, a classic case of total abuse of the copyright law by someone who knew better, or at least had been told better by people in legal authority repeatedly, and marched forward anyway. And she should be thanking her lucky stars. The legal fee was only $38,000.
Yeah, that's one of the things I said. I think Sargon's lawyers, now reading the judgment, appreciate they could have asked for more, but better off.
A lot more.
So STF-UFS said, is there any criminal remedy for Akilah refusing to contain herself? It seems she does not have the sense of God gave a turnip. She's libeling everyone now. So
in the old days, there used to be criminal copyright and criminal abuse of copyright and criminal libel laws. Even you could charge someone criminally for libel. Mostly not today. So I don't see any crime that she's committed that someone could charge a crime as at this point. Copyright abuse, if done in a certain way, can become a crime. But that's more like when you steal a copyright and do it 100 times. They haven't applied it in reverse when someone abuses a claim of a copyright. So at this juncture, I don't see any criminal charges, and it will never happen in the Southern District of New York anyway. She could have committed 20 crimes. They're not going to care. It's a political filter they have up there. Worst criminal prosecutorial office in America, Southern District of New York.
All right. And I guess to end the question as to when you take your battles to Twitter, I'm thinking it sounds like the rule I would apply would be like the Simpsons rule when Krusty the Clown was gambling, and his accountant says gambling is the best thing you can do if you know how to do it. I guess this is, if you know how to manipulate, use social media, do it. But if you draft something, it can sink a ship quickly, as was her tweets about wanting to bankrupt Sargon, because that's.
She thought she was on the cancel culture bandwagon. She was the cheerleader. She was the lead conductor on the train. But when it backfires this badly, I wouldn't keep bragging about it. But she is.
Okay, now SJW levels of awareness was only 1 minute and 58 seconds. Facts matter. Love your weekend live streams with Robert.
Yeah, but that doesn't matter for commentary. You could actually put nothing on there at all, and it's commentary. So the question is, what is the purpose of it? So they don't want to discourage someone from creative commentary. So the creative commentary could just be to play it, and he could make a statement different than the statement that she originally intended, or even be her statement. So that's all fair use. It's not fair use when you're trying to steal credit for. If this was someone pretending to be her and put up a fake YouTube page of claiming to be her and try to get super chat money related to it, that's what copyright law is about. It's not like patent law at all. It protects a different set of policies, and because of that, it's interpreted very, very differently than patent law.
Okay, now I'm looking it up. The original video was 9 minutes and 51 seconds, and it had an interesting choice of thumbnail. And it was 1 minute and 59 seconds. The SJW levels of awareness. Okay, and thank you very much, by the way, MetaZone. So that's it. It's phenomenal. It's interesting. Now, the judge he's like officially off the file. He can't come in and revise his judgment to up any award. If she appeals, it would only be an appeals judge that could change that.
No, the appeals court could could do that, but the appeals court could reverse and remand back to the district court, and then it would go back to him.
Okay.
I guarantee you every lawyer is telling her not to file the appeal. Unless there's a lawyer that thinks she's got 50 grand sitting there to give them, they may say, sure, I'll take it. You know, whether you lose is your problem. But this is a borderline frivolous appeal at this juncture.
Okay, amazing. And now, to bring us to our second subject, we are 35 minutes in. For anybody who's keeping track, I'm going to try. It was about Sullivan.
Yeah.
I took a picture of it. We'll get the super chat question, and then we're going to get into Sullivan because it's another amazing one. Go Vols. This is from Christopher Phillips. Any chance Flynn will get a fair shake with this Dem-appointed court composition? FYI, I'm a lawyer and learn so much from this. Thank you. So thank you for the super chat. I can't seem to bring it up. That's Bambugas, and that is okay. So Flynn, first question before we get there. There was the July 30th court order, which set out the question in law to be debated for the parties, which was, were there other appropriate means to attain the relief sought such that mandamus was required, or mandamus? What is up with this second court order that added a second question? Some people were hypothesizing that it was the Republican judges on the bench who were adding this question so that it should be debated. I was thinking maybe this was, I hadn't thought about that angle. I thought maybe it was just the court adding this question so they can find against Flynn on the mandamus and then find against Sullivan on the impartiality, send it to another judge who dismisses the case under the 48A. What's the deal with the second order? How do you think that came to be?
Well, because you have the nature of the panel is where I would start. And the Trump, there's two Trump appointees. One had to recuse himself. We now know that because he's not part of the panel in the second order that was issued, because he was the deputy White House counsel when the Flynn controversy first occurred. So theoretically, he has factual knowledge relevant to the case. So he disqualified himself. It may have been him, by the way. He may have pointed out in his self-disqualification, wouldn't this disqualification apply to some other people too? Not sure. But he stepped down. And so I think you have a panel currently of 8 Democratic appointees and 2 Republicans. So you have an incredibly Democratic leaning court. And I think the interpretation of the first order was correct. So I was surprised by the second order, but it would go to a second issue that I've talked about a lot on this stream, which is that the problem for judges going along with this, even the Obama and the liberal Democratic judges and the Clinton appointees, is this opens up a dangerous can of worms to let judges go AWOL and start appointing their own prosecutors to cases. And this has never happened before. Nothing like this has happened before, anything comparable or analogous. Sidney Powell's done a good job of pointing that out repeatedly in multiple contexts. Not only has every motion dismissed been granted, no judge has ever appointed an amicus against the interest of the government dismissing a case. I know of no such case where that's ever occurred. And the problem is, if they're going to be serious, there's also a core problem with the standing issue. So the question was, how in the world does a judge have standing to bring a petition of writ? It's one thing for a writ to be brought against him and him to respond to it. It is quite another for him to initiate a petition like he did here, where he petitioned the Court of Appeals to hear the case en banc. That is normally only a party can do that. In fact, by rule, only a party can do that. So they decided that somehow he was a party, but then I guess somebody got the intellectual recognition that if he is a party, how is he still in the case? Because under the rules, once you're a party, and it was for him to have standing, he has to recuse.
And so let me stop you there, because there was one question that I think came up, and I think one of the judgments cited answers it. He has no standing for to issue the petition for rehearing because he's not a party. My question would have been, had the decision been to reassign, to remove him from the file and reassign the case, would he then have had standing to petition for rehearing or appeal that decision? And if I recall correctly, one of the decisions that they cited specifically said that a judge who had been reassigned sought, petition for rehearing or sought to appeal that, and it was determined that they have no standing to even appeal the reassignment. Is that right?
Correct. So they have a complete debacle on their hands that if they completely whitewash what Flynn did, they've set a bad precedent for future judges. On the flip side, they don't like Flynn. They don't like Trump. So they don't want to reward Trump and reward Flynn with an immediate writ issuance. So it may be the case that they're going to do a compromised verdict And I think this is the most common prediction right now, is that they're going to say the writ didn't have to issue because there was the district court could still provide the required relief. That's not quite true in my view, but because the problem here isn't just his refusal to issue the dismissal. If that was the only issue, then they could wait until he heard it. But he assigned a special prosecutor. They can call it amicus, they can call it whatever they want, but that's what that was. And that's the remedy for which there was no relief other than a writ. And my guess is that's what the government will argue on Tuesday. I think the oral arguments on Tuesday. And they'll say, no, we need it writ issued now because the harm is the appointment of the amicus. And so now it's true from Flynn's perspective, that's a partial harm, but the real harm is the failure to dismiss. My guess is, and most lawyers' guess now is, I think your guess was as well recently on the one of the things you did, was is that they're going to cut the baby in half, whack Flynn, and not give Flynn, in terms of not giving Flynn the writ that they want, but really whack Sullivan and give the ultimate relief by saying Sullivan has now made himself a party to the proceeding. We believe that he does have standing, but that very act of getting standing means he had to recuse himself from the file. We're going to remand with an order that he recuse himself, the case be reassigned, and because they figured that could resolve the problem, that the new judge won't have the amicus still appointed, that the new judge will just dismiss, and so the same remedy will happen. It'll be delayed a week or two. And actually, to be frank, I bet Sullivan wouldn't have done this if he'd known that was the solution, because that's a worse outcome for him, because now he's being told he failed to disqualify himself when he was ethically obligated and legally required to do so. That's a worse thing in your judge's file, is a biased judge under the law, that's what its definition is, who failed to disqualify himself when he was supposed to. I'm sure that came as a shock. You saw almost nobody on the left make any commentary about that order. It was almost everybody on there. They were thrilled with the first order, but the second order just didn't quite show up on their news headlines.
So much so that I didn't even hear about the second order. Someone had sent it to me by email. I think the article was in the National Review. No, it was mind blowing because it changed the entire debate. Where the initial prediction I made like 2 or 3 months ago was that the Court of Appeal wasn't going to grant the mandamus, but was going to draft an order in such a way to let Sullivan know that he had overstepped the bounds. Do what you have to do under law, but we let you make the decision. That might be what's going to happen now, but it's going to be another judge because Sullivan has gone overboard. Some people were asking, if it gets reassigned to a new judge, does the judge have to take cognizance of the entire file? Does that add months and months of delay?
Or he can do it now. He can do whatever he wants as quickly as he wants. Now, it's going to be key. There's a lot of liberal judges in D.C., and of course, there's the famous Roger Stone judge in D.C. If she gets it, she'll start it all over again. She'll appoint her own amicus. She'll do the whole shenanigan, the whole show. So it's going to be critical who gets reassigned. I think some of them are going to, some of the Clinton appointees in particular, that's probably your swing vote. The Obama appointees do not have a majority. I think they're 4, maybe 3 or 4. The Clinton ones are more pragmatic, and so they may ultimately say, screw it, we'll just say he doesn't have standing and say that no petition for en banc was improvidently granted, denied, the writ is now enforced. It wouldn't surprise me, put it this way, to see them reconsider how they got down, because here's the problem. They've just said somebody has standing who, by definition of having standing, had to disqualify himself immediately. That's sort of a dumb kind of provision to hold. Just say he doesn't have standing in the first place.
But so that answers one of my questions. Is people think that if this gets to another judge, everything starts over again. They can do exactly what Sullivan did, and it's sort of like it's Sisyphus's rock. My feeling was that no judge would be as stupid, judicially stupid, as Sullivan has been, having seen the way Sullivan is going to presumably get spanked, has gotten spanked, dragged to the mud, whatever. No judge would do that again. They would just
Judge Jackson will gladly top him. This is a judge, remember, who after Roger Stone was commuted, tried to prevent his commutation. She demanded, I want to see the commutation. I want to see if everything was commuted. Oh, yeah. Well, El Trumpo had commuted every little thing. He had some smart criminal defense lawyer go through and make sure every little thing was commuted. But that gives you an idea for how nuts she is. This is a judge who, when she was exposed to juror bias, tried to cover it up rather than deal with it. So she will happily she'll go further than Sullivan did. So that's where I think if they think it through, they have to trust that a new assigned judge doesn't recreate the problem to where they all look bad. The Clinton judges are smart, are pragmatic enough to know what can of worms they're opening. The Obama judges generally don't care. The outcome justifies the means. Doesn't matter how you get there. The law is just like we're talking about with earlier with Miss Obviously. Obviously it is the case that with Obama judges, they don't believe in truth. The truth doesn't matter. Truth is no longer relevant. It's every truth is subjective, which is actually back to both communist and fascist era logic. The Nazis believed that there was Jewish science and German science. There was no objective science. We're back to that world. That's that sort of deconstructionist world that a lot of these people who grew up with believing legally, and that they see their power as power. So the Obama judges will want Sullivan upheld. The Clinton judges are probably looking for a compromise that doesn't create a permanent problem in the judicial process.
Okay, amazing. And I'm just going to read Nabadi's super chat. Thank you very much, Nabadi. Partisan officials have almost destroyed rights in America. No right to privacy. We need a license to travel. We can't go to church or protest unless you are part of the party, etc. What can be done to free us when our judges are against us?
That's the problem. The problem is right now there's no meaningful remedy. So to give another example of that on the it's probably a good transition into the McCloskey case. By the way, there is a right to travel protected under the United States Constitution. That actually is now it's between states, not within a state. But in fact, that's why you have a right to voter registration late. A case Dunn versus State of Tennessee. You can register up to 30 days before an election because it protects the constitutional right to travel. So there is, in fact, a constitutional right to travel. I always remember the great movie Hunt for Red October, and where in one of the scenes in that movie, one of the guys says, "Oh, you mean I can travel from state to state without papers?" And of course, how ironic that is now, because now pretty soon you're going to have your little COVID vaccine chip in your finger, courtesy of Bill Gates, to be able to go to the grocery store. So we'll see how all this unfolds. But yes, it is a significant when people start now. The real check is public outrage. So when the courts start recognizing that they've outstepped public support to such a degree that the system's credibility is at risk, then they usually step back. My concern is that the new left judges don't have that perspective whatsoever. And they live in the kind of world that Akilah obviously lived in, where, she had to keep getting smacked and hit and smacked and hit, and still doesn't even recognize what happened and what the truth is. So good transition to the McCloskey case. More evidence came out of the McCloskey case this past week. The police officer investigating the case found evidence supporting the McCloskey defense. And the original assistant prosecutor was drafting a false probable cause affidavit, and the cop kept calling him on it. So the prosecutor threatened him, called him up and cussed him out, left a voicemail for him. We can guess who's leaking this stuff because we have the copy of the voicemail to the press. So, and threatened the police department, and demanded that the case be brought, quote, now, just a week before Election Day in St. Louis when the prosecutor got reelected. So it was clearly manipulation of the case for prosecutorial purposes, and he was willing to lie in the affidavit. And what's critical is here's the things he was going to say. He was going to say that wasn't a private street. He was going to say that the gate was open and that it was not broken into. He was going to say that it was completely peaceful. What the officer found from verified evidence on tape is that there were 4 separate threats made directly to McCloskey on videotape. One of them saying, "We're going to come back to your house." Another one saying is, "We're going to destroy your business." Another one talking about burning things down. And another one cussing and saying, "We have a gun too." So basically the cop confirmed his case, and they were going to lie in the affidavit. He tried to get him to not lie in the affidavit. They still withheld evidence in the affidavit, all in order to get elected, for which she's yet to face any meaningful consequence. She got rewarded at the ballot box for it. So that's the disturbing situation that we find ourselves in. That's going to go down as one of the most egregious misconduct cases in history of a high-profile category.
You said something interesting before, is that that there'll be the pushback when there's public outrage against the judicial activism. Oh. One thing I'm noticing, from the Flynn case is I'm not shocked by the amount of comments to this effect, but there's enough. People still saying he pleaded guilty. He's getting what he deserves. As though, it's such a, on the one hand, it's just a superficial understanding of the story and limited.
And it's legally wrong. Lawrence Tribe made that same mistake. He said, "Oh, he's been convicted." I was like, "Come on, you teach criminal law at Harvard Law. You know that's not a conviction." Saying that you plan on pleading, which is what that was, but the plea is not decided until the final plea hearing. The plea is accepted. Until that point, that is an intention to plea under the law, but not in fact a plea, not a binding plea, not a final plea until the plea hearing accepts the plea fully, which Sullivan had refused to do. The first judge who held a plea hearing had to disqualify himself, but didn't do so until after he took the plea. By law, that means that plea is null and void. So there never was, in fact, even a plea of guilty legally in the Flynn case. And of course, there's not a conviction until a judgment is issued. So you have these people misstating the law routinely. A lot of ex-federal judges doing it. I see they complained about the Flynn appeal decision. I mean, what I challenge all of those people to do is say, cite me one case in the 200 plus year of American legal history that has any of these facts where this took place, where a judge did what Sullivan did. There's none. They can't point to a single one. And that's their problem. Why are all these unprecedented events happening against people of a particular political persuasion? So has there been other bad political cases in U.S. history? Absolutely. To give you a little comparison, great new documentary out there. We'll put it in the links below, I think is the phraseology on YouTube. Called The Last Narc, available on Amazon. And what's interesting about this is one of the guys that gets a lot of flack for conspiracy theories, of course, is Alex Jones. But he was one of the very first people talking about this way back in like the late 90s. He had talked to some people who knew DEA agents, and he said that there's a famous case. It was made more famous in Narcos Mexico season 1 on Netflix, which it involves a DEA officer who was kidnapped, tortured, and killed in Mexico. One of the most famous cases like that in the history of the United States. Well, Jones was reporting in the late 90s that CIA people were involved and U.S. high-ranking officials were involved in the death, and that's the reason why the investigation always went sideways. Well, that he was, of course, that was all written off as, oh, that's a crazy conspiracy theory. Well, the head investigator for the DEA, longtime law enforcement officer, has now come out and went on and they have all the other key witnesses. And in fact, Felix Rodriguez, famous CIA, known as Max Gomez, is his alternate, all kinds of corrupt CIA activities back to the 60s, was actually one of the people torturing the DEA agent. And that someone within the DEA office in Mexico that was working with the DEA officer helped rat out and set him up to be tortured and killed. Backstory is what happened was the DEA agent stumbled into the beginnings of the CIA drug arms connection that was using the main Mexican drug cartel at that time in Guadalajara. He didn't know he had stumbled into it, but they were paranoid that he had. That's why they kidnapped him. That's why they tortured him. Then they find out he didn't know it, so they just kill him and blame the drug dealers who orchestrated the actions, who were not, in fact, the ones behind it. The ones behind it being high-ranking Mexican political and governmental officials and high-ranking officials within the CIA and a key person at the DEA. I started recognizing that Jones's theory was likely correct some years ago because I followed the case because they later on they would go and kidnap a doctor from Mexico, bring him back, and there was a big question about whether that was valid for personal jurisdiction purposes without an extradition treaty. Went up to the U.S. Supreme Court, United States v. McChain, decided 5-4 that they could in fact do it. I disagree with the Supreme Court decision, but because of that, I tracked that case. What's fascinating is he walked, and everybody walked, and they walked because a person celebrated in Narcos Mexico appears to me to have likely been on the Mexican cartel payroll all along and likely ratted out the DEA agent. They only hint at this in the new Last Narc series. I suspected it because he got on the stand, was a high-ranking, they had successfully extradited someone who was a major drug dealer who was connected to the murder. And he got up on the stand, the head DEA guy in Mexico during that time period, and said, oh, that guy was never a drug dealer. And everybody was shocked. The prosecution was shocked. Everyone else was shocked. Well, how did the defense lawyer know to ask that question? So my hunch is that was the guy that was on the take the whole time. That's interestingly enough celebrated in Narcos. It turned out he may have been the rat for the Mexican cartel all along. But it gives you an example of how criminal justice works. I mean, they covered up. No one was ever prosecuted successfully for that murder in the United States. And the key facts about it were covered up and hidden for 25 years until this officer decided to come forward and give the whole story. And they got fantastic. They got firsthand eyewitness evidence of the Mexican law enforcement officials that were part of the kidnapping, part of the execution of the kidnap, part of the whole thing. It's a fascinating documentary, and it's a reminder of the scope and scale to which our government will go to cover up their own corrupt misconduct, even when it involved the torture and murder of one of their best law enforcement officers.
Yeah, that's fascinating. Almost too much to digest. What was the question I was going to ask? In the McCloskey case, the cop who came forward, has he been identified? Has he been publicly?
Oh yeah, I mean, technically, apparently these records are somehow disclosed through Freedom of Information Act or something. It came to the press. People can see the good 10-minute description on Matt Christensen, who I think comes up right, I think almost as we end, not long after his YouTube thing comes on. Occasionally we've stepped on him, so I'm trying to promote him a little bit. In terms of his time frame for his live stream. But yeah, he has a good 10-minute version of it, and apparently it comes from the supposedly FOIA request. But given how I know how those operate, here's the backstory in St. Louis. The prosecutor there is suing the police union. So the police and the prosecutor's office are at war in St. Louis. And so the cop was trying to do an honest job, put under great pressure, and he basically was not happy with how the prosecutor treated him. The prosecutor, basically, the assistant prosecutor assigned the case, basically threatened the police department that he was going to increase the riot pressure by saying that they are the ones holding back evidence to be able to prosecute the McCloskeys. So that gives you the mindset. It also makes it how clear it is. The St. Louis prosecutor's office is in the pocket of Antifa, BLM, the rioters, and the looters. That they have been weaponized to promote the looters and the rioters against the interest of people who try to defend themselves. It could not be more clear than the evidence that's been released. But it's been released by local media there, and it has emails, it has voicemail recordings, it has a correspondence back and forth, it has all of it. Presumably, theoretically, not leaked but disclosed under FOIA. But that's the fastest FOIA response I think I've ever seen. So I'm still trying to get FOIA documents in the Amy Cooper case in New York. So in my other typical cases, they take months. And right now they're taking like a year. So that's because the St. Louis cops decided to pay back the prosecutor. And so that gives you an idea. That case is a joke, that they can't even go forward, because that means the lead cop on the case is going to get on the stand and exculpate the McCloskeys. That's what that means. I think she only brought it to win election. I think she's probably going to let it go not long after.
What are the chances? I mean, can the feds get involved? How does this escalate? Who what's the word from The Simpsons? Who polices the police? I mean, literally, this is where we're at.
Only if there's a civil rights violation, which there's an argument that there is. The U.S. Attorney's Office from St. Louis could investigate the St. Louis Prosecutor's Office on grounds that they engaged in civil rights violations, a conspiracy to violate the civil rights of the McCloskeys, given what they did here. So, yeah.
And
I wouldn't bet on it. They're running around chasing stupid cases out of the federal prosecutor's office in St. Louis. So one of the weaknesses of the Trump administration has been that he has not reformed deep state apparatus. And what I mean by that is people who have key decision-making power in law enforcement, prosecutorial decision-making, intelligence, State Department, diplomacy. Almost all those people are controlled by people who hate Trump.
I would imagine not the only, but one of the good elements of this is that the people they've decided to do this to seem highly litigious and have the wherewithal to use the legal system and not put up with crap, and might push it as far as it can go. It's interesting. I don't believe that I've heard enough of this for as egregious as it is in the mainstream media.
Oh no, they've completely buried this. If I hadn't come across Matt Christensen's thing, I wouldn't have known about it. So, I mean, that's how fast. I mean, like, it's extraordinary, the amount of the places you have to dig to get honest information. Well, like, take Last Narc. When I saw Last Narc, I was like, do they really have these people? And I was like shocked. I watched the whole thing, like, what do you call I binged it right away. And I was like, wow, this is the best evidence of government misconduct in the history of it. Makes JFK look like the film Small Change. I mean, this is extraordinary. kind of thing. But yet the mainstream press has hardly said a word about it. You have one of the biggest scandals in the history of United States politics, and the institutional press hasn't said boo. It's amazing how much they are in the pocket of the certain corrupt institutional actors. It's unfortunate.
It is. I mean, that's shocking. Someone had sent me the link and said look into it, and I could only see it summarily. And what I had read was that one of the police officers refused to reassemble or refused to alter the weapon that had been rendered unusable. But
yeah, that was just one of many parts of it. I mean, basically, he was trying to get the prosecutor to not lie in the probable cause affidavit. Gave him all the evidence that showed that, in fact, there was no basis to bring a charge at all. I mean, it was just, and all these people that were yipping to me on Twitter about, oh, that was a totally peaceful thing. There's no evidence it was criminal. Yeah, actually, there was. The law enforcement officer found 4 specific threats made directly to the McCloskeys on videotape. Also, of course, the gate was damaged. That is a private road. I mean, it was just one lie after another. Now, that tells you about what prosecutors are used to. They never get caught for lying to judges. No, judges just don't do anything about it. And watch, in this case, that there'll be nothing done to those prosecutors. Just like there's been nothing done to the prosecutors for lying to the judge in the Flynn case about discovery that clearly had been hidden that was exculpatory.
Okay, amazing. Actually, someone had asked a question earlier about Flynn. Sally Yates saying that Comey went rogue. Is that going to have any impact on the case?
Well, it's a great opportunity to remind everybody of the eternal truth. Sally Yates is corrupt.
There were 2 truths, Robert.
Yeah, well, the second is Epstein didn't kill himself. So those 2 truths still true. But in the news again was the Sally Yates is corrupt one. She tried to lie and hedge to the. She tried to shift blame. It's interesting. There's now an institutional narrative. I think it's being orchestrated by Obama's people to blame Comey and to blame low-ranking people. They always look for the lowest person on the totem pole to feed to the machine. That's just the way the machine always works. They're like, can you? When I have a case, if I can give them somebody low on the totem pole in government misconduct, they're happy to give my client whatever he wants, and we get to walk. And their only remedy is always somebody low on the totem pole. I've got some people higher on the totem pole, but that's brutal to get to. So yeah, it's clear based on Rosenstein and Yates' statements that they are now blaming everything on Comey, on this younger lawyer named Kleinsmith, because they have him actually doctoring documents with easy proof. On McCabe, that's where the blame is going to go. Not to Brennan, not to Clapper, not to Yates, not to Biden, not to anybody high-ranking other than Comey to some degree. And Comey, of course, is also saying he was kept in the dark. And McCabe is saying he was kept in the dark. So, and Peter Strzok's even kind of saying he was kept in the dark. So if anybody is hit, it's going to be Lisa Page, Peter Strzok, and Kleinsmith. I wish it was someone higher up, but that's just not the history of the government, sadly. They just do not clean up their own. Even though it's now become more evident. I've been telling people now for 3 years that if you want to understand what the Steele dossier is all about, go and watch 2 movies or read 2 books by ex-spies turned literary authors, one Graham Greene, the other John Le Carre. And the first one is called Our Man in Havana, black and white movie made right on the eve of Fidel coming into Cuba. And the 1990s movie Taylor of Panama. And the point of those is that what spies often do is just make stuff up. And they often find some local bogus source that actually doesn't have any connection to anybody, anywhere, any place, but just has a good imagination. And that's what they print up. And that's all the Steele. We now know this week that was all the Steele dossier ever was. He didn't even have a source in Russia. They didn't even have a source. He had a source with a Russian name, but was here in the United States working over at the Brookings Institution, who was just talking BS over beers. And he recorded this as prime source, Russia #1, close to Putin, and he knows that spy verbiage. And Steele mostly didn't. I mean, Steele wanted Trump out, but mostly Steele's just getting a huge paycheck. He knows that the crazier the story that feeds into the fevered imagination of his critics, the more people be, oh yeah, that's great, and it would pay him more and more and more. That's the scam, and that's what Our Man in Havana is all about. And the reason why it came from spies turned authors is both Graham Greene witnessed it when he was a spy in Africa during World War, I think it was World War I, maybe World War II. And then John le Carre witnessed it himself as well. And so they're like, this is how the spy world really is. It's 90% completely bogus. And that's what it turns out the Steele dossier was. They knew it the whole time. They lied about it. Sally Yates, I mean, the real conspiracy was launched with Sally Yates, Susan Rice, James Comey, Barack Obama, and Joe Biden in the Oval Office on January 5th. I mean, when Susan Rice is writing, the CYA emails on January 20th, like 1 minute before inauguration. By the way, on this meeting on the 5th, everything was totally legit and clean, and that you don't need to write that unless it was totally not legit and clean. She knew that they were going to be in trouble, and so that's who should be prosecuted. Probably none of them will be. Sally Yates tried to get around Senator Cruz, to his credit, asked a good question. He's pointing out, weren't you spying on the Trump campaign? It's like, no, Carter Page wasn't an advisor at that point. And she's like, hold on. And he was like, hold on a second. You got a FISA warrant, right? And FISA warrants allow you to not only spy on that person, but anyone they've been in communication with, correct? And it allows you to go back in time when they were working on the campaign, correct? And so she just tried to lie about it in ways that works when you're talking to some 26-year-old kid writing at the New York Times or the Washington Post, but does not work with someone who knows anything about FISA. So she should be criminally prosecuted. She clearly was part of the setup of General Flynn, was clearly part of illicit authorization of illicit spying. Illicit unmasking was the other way they were doing spying, because unmasking is a way of spying without even getting a FISA warrant. All you do is say, oh, that conversation looks interesting. Tell me who that was. Because the NSA listens to everybody's conversations all the time, in case people haven't figured that out yet. Watch anything on Ed Snowden, and you'll understand what he was talking about. But the people who should be prosecuted, Brennan, who orchestrated it, Clapper, who orchestrated it, Yates, all of whom were likely involved with illicit leaks of confidential information, all of whom were involved with illicit unmaskings for politicized purposes, all of whom were involved in the conspiracy to spy on the Trump campaign and related associates and affiliates with it. All of them were involved with selling a bogus Russiagate narrative. Unfortunately, it is unlikely that any of them will actually face prosecution. Lindsey Graham waited to the last possible minute to do a hearing. He's only doing it to make sure he doesn't lose his re-election bid in South Carolina this November. The guy is just a fraud. He's not a serious guy. And anyone who takes him seriously is wasting their time. I told people that a year ago, as soon as he was going to be up on the Judiciary Committee. But given the dynamics of what was revealed this week about the subsources revealed just how embarrassingly bad we have had a real life Our Man in Havana, Taylor of Panama, actually happened in documented time here in the United States, and it's the Russiagate story.
It's amazing. I mean, that reminds me of a tweet that Brian Stelter just put out, which was him asking a panel whether or not there's any Is
there any network out there that just criticizes Donald Trump the way Fox is so mean to poor Joe Biden?
It was laughable, but it's
the guy's got. I'm starting to think he's a plant, because he says the kind of things that are self-satire. You know what I mean? I mean, Mark Dice is going to have a permanent living mimicking his voice, Brian Stelter's voice. And now you have this. I mean, that was just, but to some degree, that's their self-delusion level. The echo chambers are as intense as ever. And the left, unlike the right, will always be bombarded with the left's news and knowledge, because the left controls almost all the cultural institutions. I turn on Major League Baseball and I'm getting bombarded with BLM advertisements. I'm watching NBA and all of a sudden the guy's talking about one of those murderers in Louisville going to be indicted. And I'm like, okay, you're an NBA player. I really didn't tune in for your interpretation of the Breonna Taylor case. And my strong hunch is, if we sit down and chat about it, you don't know much about the Breonna Taylor case. And if you're going to try to make a difference, find a case that's not all in the national news that will get you brownie points on Twitter. Find a legitimate case. I have several of them. Other lawyers have many of them across the country, maybe in your own hometown, that can make institutional reform possible. But that's the world we live in. These are people who live in so even when NBA ratings are shockingly declining in an environment they should be skyrocketing with everybody stuck at home, golf is hitting records. People are so turned off by the politics of what's happening in the sports. They're actually watching golf. I mean, there's no better evidence of the problem.
Well, golf, wait until bowling starts picking up, because I've been watching bowling, but it's still not quite as aired as popularly as golf.
No, but it should be. It's more interesting to me than golf.
I love watching bowling. It's the perfect sort of repetitive motion to relax you. I was going to ask you a question, and I think I forgot the question now.
Well, a good transition for politicized cases is the insanity of the New York Attorney General trying to go after the NRA.
Okay, so now this is the one where I had prefaced this earlier. I know nothing, I think virtually nothing about this. So can you set it up for anybody who knows nothing? What is the basis of this lawsuit for someone who's never heard of it?
So background is the NRA is a not-for-profit charitable institution. It's set up in New York after the Civil War to initially to train people how to shoot their weapons, and it was started by a bunch of Union soldiers who were who were disgruntled at how superior in arms the Confederate soldiers were. The Confederate soldiers were a lot better with guns than the Northern soldiers were. Now, that shouldn't come as a great surprise, given the South was far more agrarian than the North was. The North had a lot of immigrants from European cultures that hadn't used weapons as much, and the South was really frontier country, at least at some point or another. So everybody who founded the South, other than your cotton planters, they're a bunch of lazy bums from the South of England. But I got my own grievance there. But the rest of the South, your upcountry South, was very much. Hold on one second. There we go. I usually always have my ringer off, but then people complain. So c'est la vie. But they started the NRA in order to train Northerners how to shoot better because they were like, man, we got a problem. And one of their original targets, actually, interestingly enough, were actually ex-slaves. They wanted to teach ex-slaves how to defend themselves, and to arm ex-slaves in the 1860s, 1870s. Had they been able to sustain that and maintain that, we may have had a different Southern history. But the NRA, but they've always stayed in New York for that reason. So they're historically based out of New York, and they're organized as a not-for-profit. So this woman who ran for attorney general, promised to go after Donald Trump. I told people at the time, I was like, I've never seen this before. You'll say you'll go after categories of criminals, but you don't normally say, hey, if you elect me, I'll make sure that person ends up in jail. I mean, it's the old Soviet mantra from Beria to Stalin: show me the man and I'll find you the crime. And it's what they did to a lot of the Trump associates and affiliates, in my view, both Mueller and his predecessors under the Obama shadow government that was operating effectively because Trump couldn't get his own people in for forever. So what's happened is she ran on attacking the NRA. She said she was going to kill the NRA if she got elected. So she gets elected, and the NRA thought they could play nice, provide information, documentation, so forth. They even tried to go woke for the last 3 months. All that did was backfire because that communicated vulnerability. Appeasing, bowing before a king only gets you guillotined, is what I like to say. So it's like dealing with the government, never bow before the king. You got to go up and punch them in the nads. Then that gets their attention, and maybe they'll do something. So she decided she brought civil suit last week. Her grounds are she wants to completely disband them. And to understand the legal background of this, there's a means by which you can disaffiliate a corporation, or you can get dissolve a corporation or dissolve a charitable entity. But that's to protect the point and purpose of the charitable entity, not because you disagree with the politics of the political entity. Her predicate of doing so was to just scroll through every record that the NRA has. By the way, the NRA disclosed that they turned over their entire membership list. Unbelievable. They should have fought that in a civil rights case right away. They're like, oh, but they promised us they wouldn't disclose it. Of course it got disclosed, you idiot. That's just sad. The NRA has some bad counsel right now, or up to this point at least. So she decides that based on financial transactions of certain high-ranking officials at the NRA that she thinks are outside the NRA, the not-for-profit rules, self-dealing allegations, things of that nature, that she's alleging that she can dissolve the NRA, which is insane. The provisions of dissolution are for when a company or a charity is no longer able to serve its purpose, where you're protecting its donors. Clearly, she's not out to protect its donors. So you even had the Washington Post today have an editorial saying it's an outrageous abuse of prosecutorial misconduct. And it led to where the NRA has been effective and smart is in civil suits. They filed a federal suit in the Northern District of New York on grounds that this is a blatant 1983 violation, that this is a classic case of selective prosecution. Now, normally selective prosecution is brutally hard to prove. They make it that way for a reason. Not a good reason. It's to protect the political powers that be. But here she's so overt and so open in what she's doing. And when you're getting criticism from the Washington Post and you're getting criticism from Jonathan Turley, both left-leaning legal sources or political sources, then that should tell you how bad it is. But she doesn't care. She's completely tone deaf. New York is tone deaf right now. They're not paying attention. I mean, nobody would have normally prosecuted the Amy Cooper case outside of crazy politics. That's what's happening in New York right now, and she's the ultimate example of it. So I think the NRA may win their federal civil rights suit, and she may be. They're asking for a stay, which is very hard to get in a pending criminal case because of interjurisdictional issues and some abstention doctrines that say you cannot sue to stop a federal criminal or state criminal proceeding in federal court. But I think they may win ultimately on declaratory relief. It tells you something that they think they cannot get relief from the governor and cannot get relief from the New York State court judges that they went to federal court. But it's an egregious abuse of political power. It'd be like the state attorney general of Alabama running for attorney general of Alabama and saying, if you elect me, I'm going to end and terminate Planned Parenthood. And then coming up and then suing to dissolve them on grounds that they are just how they've used their money at the top.
Well, so here, let's actually, the first question. It's a civil suit under I guess some sort of corporate law act, which seeks the dissolution of a company.
Or in this case, charitable institutions law.
Okay.
The state attorney generals have very broad authority over charitable institutions.
Okay. Now, and I would presume, I don't know the case law, but I presume it would be something similar that my battery is not plugged in. Hold on 1 second. Holy cow. I presume it would be, even if there were these monetary violations, that they were acting as a for-profit on certain elements. I would presume that the standard sanction would be monetary penalties and not dissolution of the not-for-profit.
Correct. And that's an extreme remedy that is almost never granted. I've done derivative lawsuits where that was on the table. Judges hate to grant that. They're just not going to do that. And they're definitely not going to do it when the people that the NRA is designed to serve don't want it. I mean, that's what's unheard of here. Normally, when you bring an action to dissolve, it's because the original donors, contributors, shareholders, whether it's a charity or a non-charity, want that to occur, or some big group of them want that to occur, or the purpose of it no longer exists. It is unheard of to seek to dissolve a charity when everybody that supports that charity opposes the action.
So apparently, King of Casual says that Lawful Masses Leonard French said that it was a good case. I'll check out his video. I mean, but now, so here's another question.
That's people who don't know charitable law. I mean, I've done this exact law in California. I've done it in the context of New York, where what they're divorcing is policy from reality. So let me give you an example. You have a private trust or private charity, and the trustee is stealing all the money. In that context, the beneficiaries may want the dissolution of the trust and those funds given to them or to a different charity. And in that context, so what someone like French may have done just, hey, there's been past examples of where there's been misconduct at the top. They've done dissolution. Yeah, when the beneficiaries wanted that to happen, not when they don't want it to happen, and definitely not when the person ran for office saying, I'm going to disband them, when she knew none of this. So it's clearly that her political motivation, this was clearly, show me the man, I'll find a crime, number one. And number two, it's seeking dissolution that is directly against and contrary to the policy behind dissolution power in the first place.
Okay, and now is there a provision that would allow, hypothetically, worst case scenario, NRA says, okay, well, can NRA transfer or transition, from not-for-profit to for-profit corporation by modifying their articles of incorporation?
They could do that, but that creates all kinds of tax headaches for them. So the more likely was they would start a different charity, but the problem is the IRS is taking about a year to approve a 501c application. So that's why it's troublesome for them to have to go through that. The economic impact can vary too. Sometimes, by the way, here's what state attorney, it's always been a hidden power. It's like the phrase escheat to the state. So like when you don't have a will, sometimes your property ends up in the government's hands. They treat charitable property the same way. If they can obtain but here's what's supposed to happen. Someone creates a charity. The person who created it's no longer around. The trustee of the charity is completely abusing all the funds. State comes in, disbands it, and then the state often uses the funds themselves. There's circumstances where they can do that. Now, that's supposed to be very limited. I've always had a problem with that. But that gives you an idea for where they could theoretically go. It's why the suit is deeply problematic. If you can start targeting anyone you don't like politically, to disband them, to dissolve them, try to put them in prison, try to fine them, try to tax them, well, any of the powers of the state like that, politically weaponizing it like that, that is a very dangerous place to be. And as I remind people on the left, people on the right, just because people on the right haven't done it doesn't mean that the next generation won't. They're going to return the favor at some point. So this is a bad place for anybody to go. But it's where the New York State Attorney General is. It shows you how bad every aspect of criminal justice is in the state of New York.
And now the question is, what's the status of the lawsuit right now? Just the initial claim has been filed. No motions, summary motions to dismiss.
No. So two things have happened. She has filed her civil claim against the NRA to dissolve them. They turned around and filed a federal court suit in the Northern District of New York to stay it, to get declaratory relief, to get monetary relief, to enjoin any further actions along those lines. I think they will likely win some portion of the remedy, but it'll be interesting to see what happens. Also, a lot of these New York State prosecutors are ill-equipped to handle some of this. I dealt with that in the Snipes case when they were abusing a different Snipes case, not the criminal tax case in Florida, but the improper family court case in New York City. And they were completely ill-equipped for I filed the first ever federal civil rights case against them. They had no idea that was coming. Then met with high-ranking members of the Bloomberg administration who made sure to kill the case before they could get humiliated on appeal. But all the regular lawyers handling the case had no idea how this law worked. So there's a degree of incompetency along with political intransigency that is in play here. That we'll see. I mean, and then you flip from that scope over there with the NRA with New York to people having to sue to keep schools open in California. If that's a bridge to the next conversation.
It is, but let's do this one. Two chats.
Oh, absolutely.
And by the way, Jim Satala or Jim Sataya said I missed one of his chats. Put the comment back in because
we should definitely get to the super chats.
Let's see this here. So Jim Sataya, don't post a super chat. Just get your question in if you're still here. Atlas De Snyder says recently the NRA has seemingly become unpopular with many gun owners, especially among the younger of us. Maybe this will galvanize reform within or reorganization elsewhere. So,
I think they need it. I think they go back and forth on their consistency. It's the problem of the professional class. The professional class as a class has a different political perspective than working class America. And the problem is the professional class not only dominates academia, dominates our cultural institutions, dominates the legal institutions, medical institutions, but it also dominates our political class. And so that's why your Republican political consultant is mostly an idiot. That's why they're all on the same professional class bias. That's why you see all these corporations bowing to the new woke gods without even second guessing or wondering whether this is the best idea. So it's because the professional class dominates the marketing environment in most places and dominate. And so most of the high-ranking people at the NRA are completely clueless. They're the kind of people who thought Trump was going to lose in 2016. So they are deeply out of touch with the everyday gun owner, and they need to get back in touch with the ordinary everyday gun owner. Because the number one thing they still do a lot of the hobby, and some of their history was based in this, but like a lot of the left still thinks that most people are arguing for gun rights to either hunt or as a hobby. That's not it. 90% of gun owners have it to defend themselves and their family and their friends and their property. That's what they have it for. And that, in fact, was the original premise of the NRA, the primary premise. They end up doing competitions as a way to get people there, but they weren't formed solely to hold pageants of great shooting. And yet you have a lot of these people at the top that don't have that rootedness, that they don't have a history. And also it's been a little bit compromised by gun manufacturers who have their own interest. This is a member-run organization that needs to get back in touch with the ordinary, everyday member. And they should elevate people in a more little d democratic way. And then they would be much more honest. They would have known not to go along with this woke police nonsense. They would have known not to compromise with the attorney general's office, not to play ball with them. I would have sued him right away. I would have sued her as soon as she won office, because then she's under great pressure not to pursue the case. And then there's no pending criminal investigation you're trying to enjoin. Waiting until after it happens is always harder. So there's no question that the NRA needs to get its head back in the game, and maybe hopefully this will partially achieve that.
Interesting. And someone says, Eric D says, do you think the NFL is reporting their BLM activities as taxable? To which uncivil law replied, the NFL is tax exempt.
Yeah, I mean, there's a great monopoly. I mean, they have all kinds of antitrust exemptions that are problematic in my view. Through Congress, there are things about the way they're doing, and so the NCAA is about to make the same grievous mistake. They may be out of business in a year. They don't understand their own economic model. But this is because your typical university president is listening to MSNBC. They're not tuned into reality. They don't understand their own audience. Now, what my guess is what you'll see is the SEC will keep playing football this year, just like high school football is being played. The Big 12 will still play. ACC will still play. But you'll likely see the liberal professors in swing states, but who are themselves very liberal. Everybody at the University of Michigan is liberal. Everybody now Ohio State's more of a mixed bag. Penn State, more of a mixed bag. But like 99% of players by most ratings, by most polls that have been done or surveys have done, want to play in college football. This denies a bunch of poor kids the opportunities to get access to the NFL and a lot of other benefits that accrue to them. It doesn't benefit them. It doesn't benefit anybody. It's not necessary. The likelihood a college-age person will die from COVID is less than the flu. So all of this is insanity, and yet the NCAA is financially structured as a not-for-profit entity, even though everybody's making a lot of cash based on these kids' athletic abilities. And if they strip the fans of any interest in participating or even the ability to participate this year with no season, they're going to greatly regret it. The NCAA tournament is 90% of NCAA sports-related revenue. College football is 75 to 80% of college's revenues. So you can say bye-bye to women's basketball, and you can say bye-bye to lacrosse, and you can say bye-bye to soccer because there's enough money to support them. So these are people that don't. There's also institutional debt obligations that will not be met because they don't have the revenues to do so. They don't understand what they're doing, but it's because the professional class is completely disconnected from working class reality and ordinary Americana to a degree that is more severe than even the late 60s, which is the most analogous time period I know of to this period of American politics.
Super interesting. And one last is Nomad062 says, any thoughts on the Woostenberg's Chipotle couple case?
Oh, okay. I believe that's the case of the lady and her husband that were walking out of Chipotle, who they believe or felt were being harassed by an African-American, I believe, mother and her daughter. And she pulled a gun, flashed it at him, got in. They're being charged with brandishing as well. That case is not as easy a case to defend as the McCloskey case is. But I think that they are still in their right. I mean, they're reacting to the situation and circumstance. There clearly was some degree of interference and impairment. They brandished it just briefly and then put it away and then went home. I don't think that's an appropriate case for criminal prosecution at all. And I think they do have a good self-defense argument. And as I've told people, my Milwaukee case from some years ago, or actually just 2 years ago, previewed the backlash that's going to be coming, and the juries are going to be delivering. So I think that a lot of these bogus criminal prosecutions against people exercising self-defense will go nowhere. And because you have cases with far less egregious facts than Bernie Getz, and people forget Bernie Getz in New York City walked completely acquitted of all charges back in the mid-'80s. These are people just brandishing guns during a crazy environment where people are committing all kinds of violence on a nightly basis, as they continue to do in Portland. I think it's night 70 or 72, whatever it is, of violence in a row. So I think in that environment, these people ultimately will be acquitted. I think the same in the Austin case, the guy who shot because he thought someone was pointing a gun at him. And the media put out a crazy story. They said, oh, he was busy pushing his disabled fiancée when suddenly a crazy right-winger just shot him in the head. And you can see him behind the guy's car with his gun and with a machine gun and being interviewed that night talking about everybody else is a wuss and he's going to show him it. It's like, here's what I always tell people. The media can lie, that they can gaslight. A lawyer can't in court because the evidence will come out. If you tell a big lie like the media lie, there's not a single media story of this kind that would hold up for 5 seconds before an independent jury in court because the evidence wouldn't back them up at all.
But this is the problem. I mean, I think most people will agree with you, but the process is the punishment, and the politicizing the process is enough of the punishment to just deter people, not even deter, but to cause people to live in terror. And
look what happened in New York. Amy Cooper gets criminally prosecuted for calling 911 for just identifying who the guy is after he jumps her and starts yelling at her. And so a couple of weeks later, a woman is being harassed by people putting off fireworks in her neighborhood. She calls 911. They say, don't waste our time. Just go up and ask them not to do the fireworks. She does that. She gets shot and killed. So that's what happens when we send out the wrong social messages. Tell people not to use 911. Tell people that you will be prosecuted if you defend yourself. Tell people you'll be, go back and look at the Reginald Denny tape from 1992 in the LA riots. See how not defending yourself and being nice worked out for him. He's the truck driver, got the daylights kicked out of him. So they were never bold enough to try to prosecute the Koreans who armed themselves in self-defense during that proceedings. But they are now. This is what they would do today. They would prosecute all of those Koreans for arming themselves outside of their stores. That's where the left has gone. I mean, they want exclusive power. They're willing to weaponize your employment, willing to weaponize your access to education, willingness to weaponize your access to social media, willingness to weaponize your access to weapons of self-defense, and willingness to weaponize even your ability to exercise your self-defense. So it's weaponizing the prosecutorial system, educational system, political. They're weaponizing everything they can because power ends justify the means in this America.
Amazing. And by the way, just so we can all see, this might be more information than some want. Can we get this in focus? There we go. Matt Christensen is going live in 30 minutes.
So we'll lead perfectly into him.
People whom I'm subscribed to, from whom I get notifications.
That's a great guy. Does good informative coverage, and he's like one of those people like cultural indicators of what's happening politically, legally. I watch that for not only my political betting stuff, but I watch it also for legal purposes because it tells me where jurors are going to go, where judges are going to go, but especially jurors.
Well, it's an amazing thing. Like, you may not agree with him, you may think he's got some slant or some bias, but I was having this discussion with someone. When you live in the public sphere, you get called out pretty quickly when you get something wrong. And he has not been discredited for having said something outlandish, which unlike many others. And so
he's not inflammatory. He's not like all the media that is running from what got disclosed this week in Russiagate and is pretending it didn't happen. He's not poor Maureen Dowd, who forgot that Sarah Palin was a female on the ticket in 2008, recently in her New York Times editorial. Nor is the sort of out of touchness that's taking place. Of course, nothing better indicates that than California. Joe Rogan is moving from the state. By the end of the month, he's going to be in the state of Texas. Just one more example of what's happening. People like Tim Pool has gone from being for gun control to this week saying he's getting multiple guns and now opposes all gun control.
So this is the amazing thing is, first of all, someone said, rest in peace, Joe Rogan. And I had to go check the news because I thought something happened that I didn't know about. Yeah. So he's leaving the state. Tim Pool, I believe, I have always had my theory that he was a closet right conservative from the beginning, but that's sort of like more humorous than sincere.
Sure.
But I've watched in real time because I've been following him for long enough, and I've seen it's unclear, visually, if he's moving or if he's staying in the same place and the world around him is moving, which causes him to to shift in the balance. Because I believe that I don't believe genuinely that he's like a closet conservative. I think he's got a lot of liberal left wing ideas. For good or bad.
He's an old hacker. He would have been an anonymous bring down the system 10 years ago guy.
And like the last thing I saw is, it was a tweet. This has changed my views on the Second Amendment. I am now owning multiple guns. And the funny thing is, shedding the Canadian perspective, we can own weapons for hunting and for target practice, but not for self-defense, period. And
I know. And then that's what the left wants and here in the States. And that's like, no.
Well, and people look at it and they say, well, okay, in Canada, it works well. You don't have much crime in certain areas. And, we want to be more like you. Sorry. We want to be more like you. But it's a different country. It's a different population density. And it's what works in Sweden doesn't work in Canada. What works in Canada might not work in a country of 360 million people with the history.
Canada doesn't have the history where being able to defend yourself with a gun gives people a sense of security, a sense of peace, a sense of freedom, a sense of independence that's ingrained into the American psyche in ways that it simply was never ingrained in the Canadian psyche. Yeah. And so that's half the equation. The other half of the equation is we have a much higher crime problem. We have, and most of the guns that are used in crime are illegally owned. So it's not because of access to guns that we have crime problem. We had crime problem before that, before even guns existed. An open country, and there's other reasons for it too. can have a history of criminal behavior that necessitates gun ownership as a critical means of self-defense. But these days, if you go to California, your kid can't even go to school. So in terms of California is like, I don't think there's, what's happening in Canada? Are you guys going to have school in the fall?
It's up in the air. It's up in the air.
That's insane. How is that?
And you saw the tweet that I put out today. I mean, it's up in the air. In Canada, we've had fewer than 9,000 deaths, which is not to undermine or downplay the deaths. 8,900 and some odd deaths. 71% of those deaths were 80 years old or more. 90% of those deaths were 70 years or more. 82% of those deaths occurred in long-term healthcare facilities. And it's like it's a misdiagnosing a problem. There's a problem.
Completely.
Whether or not we could have ever solved that problem, because it might have happened despite all the measures you took. But now we're applying these measures, which, and it's frustrating because I've had these discussions with people, and it's just like it's you have a different framework, a different view of the world. One says, they're saying this, therefore we have to do this, and I'm saying, well, they're not all saying the same thing. It just depends on which ones you're listening to. And
not only that, the biggest thing I think is missing is the comparison. In other words, that what is frequently missed is the consequences of the policy. So that people are looking at, well, we think the benefits will accrue over here. And there's a big debate about whether those benefits will in fact accrue. But putting that aside, there's not enough discussion. There's a reason why all the pediatricians originally came out and said, yes, kids should go back to school. It's because of how much damage is done to kids, particularly the most disadvantaged kids, when there is no school. Kids that are get their health care from the school system, get their food from the school system, get their social life from the school system, get protection from abuse at home that gets reported or disclosed or observed through the school system. And then, of course, minority children who mostly will be abandoned at home. If you're poor children, minority children, disproportionately lower income, disproportionately dependent on school services, whether that's free lunch programs, free breakfast programs, whether that's a public recreation in a safe environment, whether that's access to certain educational benefits. So like the intelligent Harmeet Dillon brought the suit against the Governor Newsom for the schools and is challenging the shutdown of the schools. And it's based, I was curious what the basis was, and it's multiple. So in part, it's based on a substantive due process violation because in fact, education has been recognized as a fundamental right and a fundamental interest. So it can only be deprived under certain limited circumstances. It's a substantive due process, but she's also claiming procedural due process because there's no means for private schools or individual students to get waivers from the rule. There's also a violation of equal protection because it's discriminating. What she points out, this method of shutting down public schools will have a disparate impact on minority students, Latino and African American in particular in the state of California, and on disabled students that need special education opportunities, including autistic children. I know people who have autistic children who this being out of school has been a disaster for them. It's interrupted their routine, which is, if people understand autism, for some kids that have autism, desperately need that routine to stay functional, to stay steady. They've been stripped of that routine entirely. They have been denied the socialization opportunities and the interactions they had with individualized instructors that was essential to their learning. Lower income students don't have as much internet access, aren't as accustomed to digital use, often live in overcrowded places in urban centers, and really need that separate, independent. Often their parents don't necessarily have the highest level of education, so they desperately need access to this. What's ironic is it's Democratic constituencies that they claim to care for. Minorities, the discrimination against the minorities, disparate impact on minorities, on the disabled, on people that are on immigrant children, for whom this is the best way they get acculturated to not only English culture, but English language. So all of these opportunities are being denied, and that no way does online schooling come even close, particularly for kids under the age of 12. So it just does not work at any of the same levels. The only kids who will benefit from this are upper middle class affluent kids who can get private tutors, who are accustomed to a lot of digital use and digital access, who don't have overcrowded housing environments, whose parents can maybe even stay home and not have to leave to work. So she's smart. So she also brought it as an equal protection claim. So she has disabled kids who are bringing the claim, minority kids who are bringing the claim, and private school students who are bringing the claim, saying, look, why can't we waive it? Why can't we opt out? Why can't we take the risk? And so she's pointing out all these deleterious consequences, discriminatory consequences, and then pointing out, by contrast, the benefits to this are are not well documented. And in fact, the science appears to refute them. That if you could shut down schools for COVID, given what we know right now about the risk to children, then you could shut them down permanently because the flu presents a greater risk. The seasonal flu, which happens every year, poses a greater risk to people in that age group than does COVID-19. So I think it has an above average chance to win. Downside, you're in California. A bunch of the federal judges have been turning a blind eye. A bunch of them are refusing to enforce the law. They're allowing the Constitution to get suspended. Oh, one other addition. She's also piggybacking off of some of the successful suits. So it's a very good suit by Harmeet Dillon. She has something I think called the Center for Liberty, I think is what the center she set up for this. People can provide ways to publicly support it. The other additional good claims that she brought is, her point is that this didn't go through the legislative process. This is outside the Emergency Powers Act. This is outside the constitutional powers delegated to the governor, as other state courts have said in other contexts. Mass contacts, factory contacts in the Tesla case where they got the resolution. So her point is that this is something that, so she has every defense, every argument lined up, as well as the argument of, hey, there's not even medical evidence that any of this has any benefit to children beyond what would be normal.
No, I would imagine the argument is only that the children are the carriers to the adults, and it's to protect the most vulnerable in that age bracket. The underlying,
right, and there she has two good points. One, that the evidence doesn't show that. We have real live examples now from Sweden, from Switzerland. Many of Finland has had their schools up and operating. Germany has had schools up and operating, and I think in Switzerland they had only one incident of transmission over 6 months of schooling, or probably maybe 3-4 months of schooling. So from a child to a parent. So or to a teacher. And in that context, there could be other mitigation tactics taken to deal with. For example, you could do temperature checks, things of this nature. Yeah. Just the temperature checks, frankly, would suffice, because asymptomatic kids are just not spreading this. There's just no evidence of that yet anywhere. And so given all that, I think she's got a great argument. She should win, because he's got so many arguments. They've got to show that the governor authorized, has the authority constitutionally, has the authority statutorily, has the authority by regulation, and then that he conformed with it in the way he passed it, because she brought an administrative procedures claim under the California version of the Administrative Procedures Act. The way DACA got upheld was because they claimed the Administrative Procedures Act wasn't followed correctly by Trump. Well, there's no doubt here that Newsom didn't even get close to following, and he's just been issuing edicts like he's the Duke of Orleans from the 17th century. So we'll see how she should win with the constitutional claims of equal protection, due process, procedural due process, substantive due process, discrimination, disparate impact. But the downside is going to be that the judges, federal judges in California in particular, West Coast in particular, have been turning a blind eye to these constitutional violations by officials. But in the school educational context, I think she has a better chance than other ones, because everybody's going to know somebody upset. And even Schumer this week came out and said it's nuts to try to keep the schools closed.
Well, I mean, at the very least, the angle would be different with this case versus the others, because it is literally, won't someone think of the children and not, a burly-looking gym owner who looks like people don't mind.
They think is discretionary, or a judge who doesn't really go to church and doesn't like church and thinks it's probably a good idea that churches stay closed. Though here in Vegas, they've decided to form the churches at they're renting convention center space at the casinos, so they're holding their church services in there. So Governor Sisolak here can't do anything about it, thankfully, for the time being.
I would have gone the other way. Why not just allow gambling in churches?
Yeah.
All right. So here we got a couple of super chats. And this one's going to tie into the question where I think we should go with possibly our last subject. Barnes, if an employer terminates a person for being a tall man, would that fall under Title VII? So I presume that's
probably not. So because like a brief thing on the mask issue, it's clear that the airlines are violating the Airline Carrier Act. There's a bunch of disability laws. There's like 5 different federal disability laws. There's their own state analog laws. And what people don't realize about airlines is they have a system that's perfectly designed for something like COVID already, because they have super filters. So they're refiltering air all the time, and their filters actually will screen out even COVID particles. So they're really great already. That's why airlines have not been a super spreader transmission for COVID. But they're not supposed to discriminate. I was able to go through and prove to my own satisfaction that that mask mandates for disabled people that can't wear them because of breathing purposes violates the Aircraft Carrier Act, which is a version that I think it's AACA. It's a version of the Disability Act applied to airlines because the ADA doesn't apply to airlines directly. But it turned out that the courts have decided over the last 2 years that you can't sue for it, that airlines get to discriminate, and it's only up to the Department of Transportation to bring a civil action. So if people want to complain, they can go to the Department of Transportation website and file complaints. But I'm not, that's they have no history of meaningfully disciplining airlines. So that's an analogous situation of where that happens. So a lot of these mask mandates do violate disability laws, but it depends on your local law and who did it as to whether you have a remedy. I think you do have a remedy against the stores, and so I'm looking at bringing those suits. But it looks like you don't have a remedy against the airlines.
Okay, and that was a question that multiple people had asked, both in super chats, not super chats, in chats, in email. So that's your answer, according to Robert Barnes. Yeah, I mean, it's because a lot of people are saying, I can get into a store without wearing the mask, but if I want to travel, what's the deal? And I guess that's as good.
So what you can do is you can tell the airline you're going to file a complaint with the Department of Transportation that it violates the law, and you might get them to give you a refund. You might get them to reconsider maybe the specific airlines, but they've decided that they'll get more passengers if they just screw the disabled. So welcome to the new system.
Mm-hmm. And we got I missed a bunch of super chats, so my apologies.
Go through them. But as the tall man, bro, briefly, last height is not a protected category. And for some people that ask me, disability is not a constitutionally protected category. It's only if it's protected by statute right now. I don't agree with that, but that's the way the law is.
Okay, very interesting. Would high school athletes have a case that they are being denied the opportunity to earn athletic scholarships?
Yeah, what the universities are promising is that they will honor their scholarships regardless of whether they have the season or not, but they may not extend their eligibility, which really shafts them. That's why they're creating a huge host of legal liability for themselves and major financial revenue problems. But that's what happens when you sit there and watch Rachel Maddow all night. You think that your only risk is all the kids will die from COVID and suddenly I'll be the worst president ever and be sued into oblivion, when there's almost no chance of that occurring. While there is a big chance that your college will be out of the athletics business in 2 years, unless you're like a big one. But your small schools may be done. You also may see transfers, which I am honestly hoping for. So I'm hoping the Pac-12 and the Big Ten screw their schools over and send all those kids. The University of Tennessee could use some good transfers. So I'm okay with that. But otherwise, that's where we're at.
Okay, amazing. And this should be.
Yes, I forgot that. The Nevada lawsuit. Yeah. So what happened is the state of Nevada, Governor Sisolak, our nitwit governor, passed a law, rushed it through the legislature, didn't have any meaningful hearings, and basically what happened was the interesting aspect is he did made the whole election for November mail-in balloting, or made at least that the likely option. Then but he was over the top. He decided to create multiple voting locations in person if you wanted to go that route in Democratic areas, but provided very few in-person voting areas in Republican areas of the state. But he wasn't just satisfied with that. He decided that you no longer had to witness the ballot you had to sign it, but no longer had to be witnessed. Multiple people could help you with your signature. Didn't even have to be a family member. They could help gather ballots. And the other factor, this is the big one, two big ones. It doesn't quite. You basically you don't really have to postmark it, and they can receive it for days and days and days after the election. In other words, the way the postmarking is done, there's no way to check the postmark effectively. They've created a postmarking problem, so you can't tell when it was postmarked. So essentially, he's created a system where not only can the ballots arrive after Election Day, realistically, they can be mailed after Election Day. And so the federal lawsuit brought by the Trump campaign here in Nevada, their best claim, there's usually a lot of deference to states and how they structure elections, and that's mostly good.
So hold on, but there's deference to states in terms of how they structure federal elections?
Yeah, yeah. Because technically these aren't federal elections. That doesn't quite, that sounds counterintuitive, but what's happening is each state is voting for a person who will hold federal office, but technically they're representing the state in the federal office. So technically it's still a state election. So the same with electors. So the last time this got meaningfully, of course, debated was Bush v. Gore in 2000. It was, what power does the state have to control how its electors are decided? And historically, that's very broad. But what Bush v. Gore established was, you can't create standards. You can't change the standards overnight. That once in fact, for example, there's actually no right to vote for president. People think there is, but there's not. It's the state gives you that right. That they say, well, we're going to pick our electors by giving you a right to vote for our electors. But what the Bush v. Gore said is that once you do establish the right to a vote, then you have to have procedural due process in how you make sure that vote is counted for. And so the basis of the suit is twofold. What's interesting is this may explain why Trump had that interesting tweet last week. I'm sure he was likely aware or made aware of the lawsuits they were going to be bringing on mail-in balloting. And what they may have told him, and what the main basis of this suit in Nevada is there's a federal statute that says the election can only occur on this day for these federal offices. So that's where you have federal law, because there'll be federal offices governing it, even though states otherwise have complete control over how that person gets elected to that office. To give an example, the state legislatures used to pick senators. Then the U.S. Constitution changed and required states to have direct election of U.S. senators. So there are constitutional restrictions, but in terms of the everyday procedural regulatory control, they give a lot of discretion to the state generally. But if it dilutes the vote, so there's a Carr case, Baker v. Carr, some other cases that say you couldn't dilute the vote. For example, in the South back in the old days, rural counties counted a lot more than urban counties. Each county had equal representation, not one person, one vote. It was effectively one county, one vote. Personally, I think I'd like to go back to that, but that's another thing. But the U.S. Supreme Court said, no, that's violation. It is one person, one vote, not one county, one vote. That's a dilution of the right to vote, which you had already extended to the voters. And so you had to enforce it constitutionally under equal protection and due process. But the main basis of the suit is that the Nevada law violates the 1 day of election rule. That the election can only be held on this day, and given how loose the postmark standards are, and given allowing ballots to be returned after election day, they're saying really you're changing the election day. Now, given they filed that suit, that makes me wonder whether Trump deliberately put out that tweet of saying, "Hey, maybe we'll move election day," knowing the media and everybody would go crazy and say, "No, the law doesn't allow election day to be moved." Which is exactly what his legal theory is. His legal theory is, no, you can't move the election day. And by allowing ballots to come in after election day, and particularly when there's no clear standard for how to interpret postmarks so that they could be postmarked after election day, means that you've effectively changed the election day in violation of federal law. That's half of their claim. I think they should win on that. But here's a big caveat. Almost every federal judge in Nevada received the approval of one man before they got on the bench. And that man, no matter whether it was a Republican appointee or Democratic appointee, it went through one guy for pretty much every federal judge that sits here in Nevada. And that man is Harry Reid. So for that reason, you never know what you're going to get in an election-related lawsuit that hurts the Democrats in Nevada. The other side is they're bringing the vote dilution claim because they're saying, look, they're allowing for certain kinds of ballot. They're basically saying they're diluting smaller town and rural ballots in favor of urban ballots by where they've located precincts and by how they've structured mail-in balloting, pointing out that Nevada, I think last time, ridiculous thousands and thousands of ballots went to the wrong location. I got multiple ballots at my address. Here in Las Vegas. So I have no doubt that will happen again. Years ago, they did a study of the voter registration rolls in Nevada, and they found the entire Dallas Cowboys team had been registered to vote here by somebody in Nevada. So, that's probably what happens is people get, money if they do massive registration campaigns, like $1 per voter or whatever. They'll do fake registrations. Happens all the time. Bugs Bunny was once found to have been registered to vote in Nevada. So the Nevada has a bit of a Chicago type electoral history. So I think on the law, Trump's team should win. I don't know if Nevada courts will give it to him or the Ninth Circuit, but this is a Supreme Court kind of case. And what the Supreme Court may say is the problem with mail-in balloting is it has to have standards that make sure every ballot, the election only happens on election day. And I think what it will do is it will require all ballots to be returned to the election office on election day, or the ballot cannot be counted. And that's the number one thing people are concerned about with ballots. Now, the second concern is ballot harvesting in general and signatures not being valid. They've maintained the signature requirement in Nevada. There is still a risk of ballot harvesting risk, but the big risk in Nevada is the timing of it. And I think they should ultimately win on that. And at least a risk with ballot harvesting and with voter fraud will be substantially reduced if the Trump campaign wins that lawsuit. Go ahead.
Procedural question. I mean, how do we make sure that this has a definitive resolution within the required delays? Because it's not by election day. This has to occur within months.
All this will be decided before election day. They'll have an expedited injunctive hearing. The district court will issue a decision before the end of August. Court of Appeals will issue a decision by early September. And the U.S. Supreme Court will have an opportunity to, in fact, my guess is,
skip all that, go straight to Supreme Court?
Well, they can't really, but what they can do is they can force different courts to take action or appeal to the Supreme Court for the lack of action. So the ballots get printed in mid-September. There's some states that try to print them early. It's all a big scam to keep people off the ballot. But basically, there's a 45-day deadline to send ballots to armed service personnel overseas. So that's when they really time their ballot printing. So it mostly has to be done by mid-September. So all the courts will want to have a ruling in before they have to print the ballots. So that now in this particular context, they theoretically could issue a decision all the way up until close to election day, because this is just about how ballots get counted, not the printing of the ballot itself. But I would anticipate decisions by the end of September by the U.S. Supreme Court on this.
And it may be a stupid question. Is there no way to effectively say, we know this is going to get to the Supreme Court anyhow, skip the lower courts and Court of Appeal, and just these are the questions?
Theoretically, there's a certification mechanism, but they almost never use it.
Okay. And I'm going to get to two super chats because I noticed one put in two and I missed the first one. Sakaki Onse says, didn't the postmark issue get solved by GOP versus Wisconsin 2020? I remember a 5-4 decision. Sorry, I was told to read these slower.
That was a preview. The Wisconsin decision was a preview.
Hold on, I got to read it slower and fully for the podcast version of this. Didn't the postmark issue get solved by GOP versus Wisconsin 2020? I remember a 5-4 decision that all votes need to be posted, handed by end of day election day.
But it was the challenge there was a little bit different because you had it wasn't legislative change. You had sort of an attempt by the executive branch to change the way the rules worked. So the precise legal question wasn't before them. But I do believe it is a preview of what will happen in the Nevada case.
All right. And the second question of mine before we get to this next super chat, Trump put out two tweets. The one was opining on delaying the election day, which now your explanation could lead me to believe that was one of those gambit errors done on purpose, even if it meant losing face for whatever the reason for the day.
He didn't care about it. And he does it all the time. If he wants a certain topic to be discussed, like look at how often he'll bring up his competency test. He knows it gets a lot of viral conversation because people think they're taking pot shots at him. But in reality, what's being discussed is Joe Biden competent. That's the subtext of the conversation. So he knows, how do I get people to talk about what I want? I get them to find a way to make fun of me while talking about what I want, because it matters more, the topic of the conversation, than the personal pot shots they're taking at me. And I have no doubt that's exactly what he was doing with the election reference.
For a shout out to Shmoyoho, for anybody who doesn't know them, just did a pretty funny video where they did the man-woman plane. I forget what it was. Great song.
It's so viral. They actually did a random test with Charles Barkley, and he failed it. He could only remember 3 of the 5.
It's classic. All right, and now Corliss D says, isn't there a legal morass with governors and pharmacy boards ordering doctors not to treat patients with COVID by HCQ, killing patients or suing doctors for treating patients with life-saving drugs? I mean,
there's been suits filed in Nevada on that where they ultimately got resolution. Because in my view, it's a right of a doctor and a patient to choose medical care. How can we be in a situation where the government cannot interfere, including the most recent Supreme Court case, even in late-term abortions in many contexts, with between a doctor and a patient about the taking of a life, whether you call it a human life or not, is up to legal and philosophical and medical debate. But I mean, definitely a very substantial medical decision. Yet somehow you can't decide whether to save your life with a drug. That doesn't make any sense to me at all. So if right to choice and right to privacy includes within it the right of the medical care of your choice, then these laws and these gubernatorial actions cannot be constitutional. Now, getting the courts to do something about it, again, it's the same problem. During a time of crisis, courts run for cover and hide behind the executive branch. They don't contest the executive branch.
Okay, and let's wind this up in a few minutes just so that everybody who wants to go to Matt Christensen can.
Yeah.
Nobody says John Podesta, skip that word, had a secret war games about mail-in voting, saying if Biden loses, the West Coast would leave. Thoughts?
Yeah, I get a lot of the nuts that the left, where the left is going. They're talking about secession, actual secession. That's going nowhere. Now, I think there's large parts of America that really would not object to California seceding at the moment, but that's not happening. So all of that secession talk has always been gibberish, whether it's from the left or the right. I remember there was somebody who wanted to start the independent state country of Texas, return Texas to an independent republic. They even made a little movie about it. A buddy of mine was even in the movie. None of that's happening.
Okay, and the last question, which I think will be a good time to end, Trump put out a second tweet about agreeing to mail-in voting in Florida, and a lot of the responses to that were apparently Florida's system for mail-in voting is unique or different than other states in that it's a little bit more secure, and by doing that, he highlighted the lack of security of mail-in voting in other states. I mean, I don't understand much about that. Is that an accurate assessment, and what makes Florida better for mail-in voting in terms of security?
So for most of our history, we had no ballot at all. From the beginning of the American Republic up until the late 1800s, you just went in and said who you wanted to vote for, or you brought your ballot with you. Parties actually used to print ballots, and you would take that party ballot in, and you knew it by a signature or by a color or by an animal item or something like that. And then in the Australians invented the secret ballot idea. The U.S. initially took it up in the guise of, hey, we want to protect the ballot. We want to make sure that no one's being hoodwinked in what ballot they're being given. I think that was all a bunch of gibberish. They wanted state monopoly of the ballot because that would allow them to have more control over who could get access to the ballot. It was also a good way to discriminate against both minorities in the South and immigrants in the North, who often had lower levels of literacy. And so they solved that problem in the South by just getting rid of all poor people. Most poor people couldn't vote, white or black, in the South from about 1900 to 1950, really. They used a poll tax and everything else to do it. So we obtained a state monopoly of the ballot. We've used that. The governments have used that to keep people off the ballot with every pretext possible. But along the way, we, of course, always designed a way by which people could mail in a ballot when they could not be physically present at the ballot box. So, for example, armed soldiers. Soldiers have been filling out ballots and sending it in from wherever they're located around the world since the early 1900s. Same with disabled people who can't get out, people in the hospital, things of that nature. It's become a more sophisticated system, and we mostly know it in the United States as absentee voting. The absentee being absent from the polling booth. The mail-in balloting is just an extension absentee balloting is mail-in balloting. Now, what's different is when people are upset about mail-in balloting, what they're referencing is the California system and other proposals that are being made. And those proposals that are being made is, I should say two things. There's one legitimate movement from absentee to mail-in balloting, like Colorado, like Oregon, like parts of California, like Florida in part, where they just moved. The absentee balloting used to be hard to get. It used to be you had to not only request it, you had to meet a certain standard. You had to prove that before you could get it. What they've done is they've made absentee balloting easier. That's the way I like to characterize it, to where almost anyone can fill out an absentee ballot. And what they call mail-in balloting in Colorado is often just anybody can get an absentee ballot. Now, what the mail-in balloting that's controversial is allowing ballots to be postmarked or having postmark standards where they could effectively be sent after Election Day, allowing ballot harvesting, so allowing other people to pick up the ballot other than the post office, so that that's a natural environment for people to just fill out ballots and bring them in. Not requiring the big one, not requiring signature validation or verification. So, like in Florida, for example, you have to request the ballot. So that's a check, because it makes sure that the only people who are getting a ballot is someone who requested it, who is on the voter registration file, whose signature matches that. So you're not just sending ballots out to everybody, where you end up every year, there are millions of people on the voter registration list that are in fact dead, that are in fact no longer living in that location, no longer qualified to vote for some other reason. And so the problem with mass mail-in balloting of the kind the Democrats are proposing is they're going to send ballots to everybody. In California, they actually tried to send it to all people, not even registered voters. So the first part of the fraud check process is being removed by a lot of these quote-unquote mail-in ballot schemes. The second process that they're often removing is who can collect it, letting it be collected by random people, not a family member, not a post office person. Third is allowing not having any voter validation mechanism, such as a signature verification, matching the signature on the ballot to the signature on the voter registration card. And fourth is, does it have to actually arrive there, and what are the postmark standards if it's a postmark basis rather than a arrival basis? And the problem is, the more you dilute those safeguards is what the Democrats are mostly proposing in most places. They're mostly recommending substantial dilution of all the safeguards that preclude mass voter fraud from occurring.
Yeah, it's amazing. And someone had mentioned in the comment that Florida, having gone through what they went through, have better systems in place to ensure that they can handle mail-in voting better than some other states, which are implementing it for the first time.
In New York City, they're disqualifying as many as 20 to 25% of all ballots. Because they're throwing them out. So whatever the ballot comes in, they're saying that ballot doesn't count. Completely disqualified.
Based on discretionary or based on...
Yeah, that's the other issue. Sometimes these standards are clear. Sometimes they're like Bush Gore all over again. Is this a Chad? Is this a dimpled Chad? That's part of the issue in the Nevada lawsuit. They're saying the standards are all not good.
This was the other reason why I knew 2 hours was our limit in any case.
Yeah.
Okay, so that's phenomenal. I mean, it's another amazing stream, Robert. I mean, it's just phenomenal, and we had a lot to cover given the week hiatus. But
we had a guinea pig.
Oh, we got a guinea pig. If anyone's...
there you go.
He was out for the whole time.
We adopted an elderly guinea pig, so
that's great.
Less light, yes.
He was out for the whole time, but I wanted to show you him, but
that's okay.
But then we had to put him back.
We'll show him later. But yeah, so we're very happy we adopted a guinea pig. Robert, okay, thank you very much. We'll let everyone go. Robert, stick around so we can say our proper goodbyes. Everyone, Thank you very much for tuning in. Thank you for the super chats. Thanks for the support, the comments, the interaction. My apologies for missing super chats. And we're going to do this again next week. I'm back in town and I'm not going anywhere for a little while. So
why can you see me there but not here?
Wider screen on the ball.
That's great.
All right, everybody tuning out. Thank you very much. Have a good evening and have a good week. Okay, and I got to